Yes! Hello, my beautiful friends. What an amazing day it is. Welcome back. I hope your rest was outstanding and your day is coming to a nice, beautiful close, but not yet. We got business to attend to here today. A bunch of stuff. Minutes ago, the president came out and signed an executive order in a beautiful signature, as always, dismantling the Department of Education. And so we actually have the executive order. I was waiting for them to publish it over on the website on whitehouse.gov. Haven't seen it there yet, but Rapid Response did post it. So we'll take a look at what this is doing. And then, of course, parse through some of the usual suspects who are upset about it. Pencil Neck is fuming mad. Randy Weingarten already screeching about it. And Tish James, remember her from New York? Stinky Feet Tish, all upset about it, which means this was an amazing decision. So if you have any doubts about it, it was the right thing to do. We'll hear from Stephen Miller over on Fox News. He was there with Will Cain, Stephen Miller. And we'll see what he said about all of that. Coming up, Department of Ed just broke, and we're excited about those developments. But then, so much else is happening today. We had Pam Bondi announce the arrest of Tesla terrorists. Charges coming down against 3 people. Now, I have not seen the charges on these yet, so we're curious as to what those charges will be. But they did release a press release. This person was arrested in Colorado. Someone else charged was also arrested here, and saying that the maximum penalty could be up to 20 years in prison. So not sure we're going to get terrorist charges on this, but we are more likely to see maybe arson per se, because arson is 5 to 20. So we'll see what Pam Bondi delivers to us. But meanwhile, Elon has submitted a motion to dismiss. Elon submitted a motion to dismiss the state's case against him. Remember, a bunch of the blue states, the whiner states, like Governor Lujan, I'm going to ban the Second Amendment via executive order. Remember her? She's really upset about constitutional overreach. And so her stupid state, not her administration, let me say that. I don't know much about New Mexico. They are pretty blue, though. But the point is, Lujan is suing Elon in conjunction with Tish and the rest of everybody. And Elon submitted his reply in support of the motion to dismiss. And this is out of Washington, D.C. And this was another case that was taking place, I believe it was in Judge Chutkan's courtroom. So she already was skeptical about their claims. We'll see what she does on this. But Elon submitted his final reply over to Chutkan. So we'll come back on that. Then we've got Chuck Schumer, who is admitting the truth here, speaking the quiet part out loud, as Libs of TikTok says, explaining that they installed all these judges. So for the people out there saying, this is being a very, very aggressive towards the judiciary, you shouldn't be so condescending and derogatory towards them. No, they're Democrat hacks who were installed by Chuck Schumer and the Democrats. So if they're going to crap on the Constitution, then we'll pay them the due respect that they deserve. But that is what we'll cover in the arrests happening soon, then that have already happened. Then we're going to turn our attention to 2 short updates. So we're loaded up today. These are going to be shorter, though, because they're just not that substantive. This one was the trans case, also out of D.C., District of Columbia. Roy C. Lamberth, you remember him from, I believe it was the E. Jean Carroll case. Did he preside over that one? No, that was Kaplan. Lamberth, I think, was a bad dude for the J6 cases. So many bad judges, it's hard to keep track of them all. But we've covered him before. So he's back, and this is the trans case, and he said, bring him back to the other prison. He said that they're getting strip searched by people of their own gender, and that's a giant problem. So he issued a short order. It's a 4-pager. So we'll just hit the highlights, and then we'll see what Trump does after that. We've also got updates on the Perkins Coie case. These were those Democrat lawyers, Perkins Coie. If you recall, back in 2016, they had Michael Sussman working for him and Mark Elias working for him. And they were concocting this Christopher Steele Russian PP fake scandal, and then we're shoving that to the FBI on behalf of Hillary Clinton, working with Fusion GPS. We covered the whole Sussman trial here and much more. But this was now an order from Howell to allow them in to some degree. And Bondi responded and basically said no, because Howell said, give them little bits of access and sort of, bring them back in. And Bondi just said, no, basically, we're going to do what we need to do to handle the corrupt, dishonest, and dangerous conduct of Perkins Coie, LLP. Well, all right, so that's some aggressive developments there from Pam. So we'll go through the status report for Perkins Coie, and we'll see what else they say, but they're saying we're doing what we need to do. And then lastly, we'll round out the day with Judge Boasberg. We've heard a lot from this guy. He's the guy who said, turn those planes full of terrorists around, and the ACLU gangbang lawyers who love representing gangbangers and want to invade our country with them, well, they sued. And then, of course, we've been back and forth on this. Yesterday, we spent a lot of time regurgitating the demand of Trump from the judge, saying that he had deadlines today. Trump had to give him information about those flights, who was on it, what type of fuel did they use, what did they serve in first class, how many people, all the things. We go, wow, this is strange. Are you in charge of the executive branch now? Well, Trump provided them an update today by the deadlines, give or take, and then the judge came back down with a final order. The judge said, whoo, not happy with you. So Boasberg is demanding that Trump submits now a sworn declaration with people involved in the cabinet. Oh, so this judge is now inserting himself directly into the presidential cabinet to see what they talked about, to make sure that they're following the Constitution and not deporting terrorists illegally. So we'll come back to that one. But Trump and the DOJ have responded aggressively, and they have submitted this one. Came out today. We'll hit the highlights on it because it's a long one, but it is a petition for a writ of mandamus. So they're taking this up to the Court of Appeals, basically bypassing this judge, asking the Court of Appeals to step on this judge and just basically say this judge is violating our rights and we cannot go through the ordinary course of appeal. So there's a different petition that we can file under another statute to ask you to step in right now. And they're doing that. And so we'll cover it. So bunch of great stuff to get to today, my friends. Very glad that you're here and with us. I want to thank you, those of you who joined us this morning on our Membos stream. We have great members only streams. We do them in the morning, multiple times a week, including on Saturdays. We'd love to have you join us. It's a great way to meet other people, connect with fellow friends in the community, a great way to support our work here. And they're a ton of fun. We get to hang out, talk about other stuff that we can't quite get to here. We'd love to have you join us, watchingthewatchers.locals.com or on YouTube. Click that join button and we'll see you tomorrow for our Friday Membos only stream. We go live 12 Eastern, 9 a.m. Arizona, which is Pacific right now. So it's still morning for us. But all right, so we got a bunch of news to get to today. Thanks for supporting us, my friends. And we'll see you tomorrow. So today, we've got great developments. President Trump did it, signed an executive order eliminating, or rather dismantling, the Department of Education. And we got to be careful with our terms here because eliminating might have some constitutional problems and invite scrutiny that a dismantling or a minimization may not, a restructuring, so to speak. But we'll read through the exact executive order coming up here, which was released via Rapid Response 47 on X. But here was the momentous signing and President Trump explaining what's happening before walking on over and executing the Sharpie that saved America.
With that, I'm going to come down and we're going to sign a very important document and we're going to be on our way. People have wanted to do this for many, many years, for many, many decades. And I don't know, no president ever got around to doing it, but I'm getting around to doing it.
Thank you, sir.
So thank you very much.
Thank you. Let's do it. Nice crowd.
Should I do this?
Do it, says that young man.
It was very lucky. I signed another document that turned out to be very good for the country, and I said, let's use that same pen. I don't know, is anybody superstitious? Ron, are you superstitious? Let's use that same pen.
Nice.
Okay.
Thank you, Mr. President. Yes, so everybody in that room, including those kids, just added 10 IQ points into their brains instantly. And if you combine that with RFK's 10 points of testosterone, we're looking pretty good here. So very nice to see that happen. And I have to be honest with you, we're not as invested in the Department of Education here, per se. We spend a lot of our time talking FBI, DOJ, a lot of the other regulatory agencies that aren't as involved in the Department of Education or structured like the Department of Education, which is supposed to be a nice domestic agency that increases the intelligence of young Americans and does other things. But what we've learned is that many of these entities don't actually do the thing that they say that they're supposed to do, whether it's USAID or any other entity that we've covered here, the Global Health Council or the AIDS doctors or whomever is the subject of a lawsuit, not exactly adding a ton of value. And if you have any doubts about the Department of Education, because I think there are people get skittish when you talk about kids and education and all this stuff, let's just show you who is reacting and how they are reacting. So as you can see, Pencil Neck Schiff is here. Today's illegal act by the Trump administration will have disastrous consequences for our schools. It will mean less resources for special education, teacher training, all the things, right? It's the same pattern. So you don't even really need to look at the substance of what they're saying. They're just patterns. Doesn't matter what it is. USAID, it's going to be Ebola. Everyone's going to die of Ebola. Okay, you cut some other entity, it's veterans all of a sudden. Veterans are getting cut everywhere. Veterans are going to die immediately. Okay, relax. Now it's the teachers and the kids in the schools and the disadvantaged community and all of it. Less individualized attention and more. And, if the education system is where it's at now because of those things, maybe we should cut those things out. I don't know what the answer is specifically, but whatever it is not working. That these cuts are made to fund a tax cut for large corporations, which hasn't even been in the quid pro quo conversation at all, just made up. It says firing thousands of educational professionals, blah, 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 as the product of a public K through 12 education and the proud parent of 2 kids raised in public schools, I've seen firsthand the transformative power of good, quality education, and more. Yeah, and a lot has changed there, Adam, in the last 50 years, right? So the public schools, when you went there, are very different than the public schools that are happening now. Very different flags on the walls. So Trump's mission to gut the education department. Okay, so he's upset about it, which means we're right over the mark. He was censured, by the way. There should be a little badge here for that. Censured. Elon, if you're out there, we need a censured badge for censured Congress people. Just to be clear. That'd be great. All right, so in addition, we've got Tish, who's very upset about this. And Tish said Donald Trump's attempt to shut down the U.S. Department of Ed will harm tens of millions of students, including disabled. Now it's the disabled kids. It's even worse than the AIDS babies who are going to get Ebola. Of low-income students who rely on this agency to access a quality education, and it's illegal. Okay, yeah, we will see this administration in court. Okay, right, so obviously they're going to file like a gazillion lawsuits, and they will start to undo this. But as we've seen, Trump and the executive branch have basically all the cards. The courts can say what they want to say, but these efforts are going to unfold. And as we saw yesterday, the strategy from the Trump administration is I forgot to sign the check defense. Everything's going to go slow. And as these orders come down, the wheels are already in motion. And once the Titanic is left, can't really turn that around. Department of Ed is hitting that iceberg. So that's from James. Now, here's what the actual order says. From Rapid Response, it has not been published on the White House website yet, but this is an official White House account. They tell us, by the authority vested in me as president, by the Constitution and the laws of the United States of America, and to enable parents, teachers, and communities to best ensure student success, Trump says, it is hereby ordered We've got multiple sections. Part 1, the purpose and the policy. Trump says, our nation's bright future relies on empowered families, engaged communities, and excellent educational opportunities for every child. Unfortunately, the experiment of controlling American education through federal programs and dollars and the unaccountable bureaucracy those programs and dollars support has plainly failed our children, our teachers, and our families. Taxpayers spent around $200 billion at the federal level on schools during the COVID pandemic, on top of the more than $60 billion they spend annually on federal school funding. This money is largely distributed by one of the newest cabinet agencies called the Department of Education, which has existed for less than 1/5 of our nation's history. The Congress created the Department of Education in 1979 at the urging of President Carter, who received a first ever presidential endorsement from the country's largest teachers union shortly after pledging to the union his support for his separate Department of Ed. And since then, the Department of Education has entrenched the education bureaucracy and sought to convince America that federal control over education is beneficial. While the Department of Education does not educate anyone, it maintains a public relations office that includes over 80 staffers at a cost of more than $10 million per year for PR to say that we're good, we're valuable, we're civil servants, we care about the kids. Closing the Department of Education would provide children and their families the opportunity to escape a system that is failing them. Today, American reading and math scores are near historical lows. This year's National Assessment of Educational Progress showed that 70% of 8th graders were below proficient in reading and 72% were below proficient in math. The federal education bureaucracy is not working. Closure of the Department of Education would drastically improve program implementation in higher education. The Department of Education currently manages a student loan debt portfolio of more than $1.6 trillion. This means the federal student aid program is roughly the size of one of the nation's largest banks, called Wells Fargo. But although Wells Fargo has more than 200,000 employees, the Department of Education has fewer than 1,500 in its Office of Federal Student Aid. The Department of Education is not a bank, and it must return bank functions to an entity equipped to serve America's students. Ultimately, the Department of Education's main functions can and should be returned to the states. So that was purpose and policy. Section 2, closing the Department of Education and returning authority to the states, hereby ordered from the president. The Secretary of Education shall, to the maximum extent appropriate and permitted by law, right? So don't violate any other laws. And they sue over this. They say, you're violating other laws. Trump says, no, I literally ordered them not to, dorks. Take all necessary steps to facilitate the closure of the Department of Education. Do it, and return authority over education to the states and local communities while ensuring an effective and uninterrupted delivery of services, programs, and benefits on which Americans rely. And consistent with our authorities, the Secretary of Education shall ensure that the allocation of any federal funds from the DOE is subject to rigorous compliance with federal law and administrative policy, including the requirement that, oh, they're going to be mad, that any program or activity receiving federal assistance terminate illegal discrimination obscured under the label of diversity, equity, and inclusion, and similar terms in programs promoting gender ideology. Wow. So all of the trans flag funds are getting cut. Wow. General provisions. They say, look, nothing in this order should be construed, this is the standard boilerplate stuff, to impair or otherwise affect any authority granted by law to an executive department agency, the functions of the OMB. This should be consistent with other laws, and it doesn't create any substantive rights or benefits. So the rest of that's just boilerplate stuff. Signed by the president, March 20th, 2025, and an amazing development. We've heard this talked about my whole life. And to see the president come in there and make a swift change that is causing people like Tish to file lawsuits, right? It's not about education. It's about educating Democrats and taking money that should go to kids. By the way, we're for education here. And if we invested $1 into a child and that returned on investment to America, we would be for that as a country because that's a smart use of money. But when it goes into Democratic coffers to install useless teachers unions who are causing almost 3/4 of our students to be incapable of reading and writing, that trajectory needs to be changed. So we're doing it. And of course, Tish is suing or will be suing in short order to stop it. So now here was Stephen Miller. He was over on Fox with Will Cain, and he was explaining what the Department of Education really is and why it's going to go away.
The Department of Education here in Washington, D.C. is overwhelmingly staffed by radical left Marxist bureaucrats who are in every way hostile to Western civilization, hostile to American interests, and hostile to our founding documents and culture. And so they are using their position and influence inside the Department of Education to try to force agendas like radical gender ideology, like critical race theory, like diversity, equity, and inclusion, and all kinds of anti-America curricula and policies on the American people, on our students, on our children. So it's taking away from parents the ability to control and direct the education of their own kids, of their own families. So what we're going to do under President Trump's leadership and direction is to return that authority to the greatest extent possible to the local level where parents can control outcomes, while at the same time making sure that no federal funds are used to support racism, to support gender ideology, or support other ideas and principles that are offensive to the American taxpayer.
Stephen Miller laying it out, and I think that is obviously true. That's why the people who are most upset about this are people like Randy Weingarten, who are saying, COVID was terrible for us, but I wanted the schools to be open. Come on. We all remember what they did and what they fought for, and it wasn't the kids.
COVID was a terrible time for us. And as you know, because I was on your show a lot and other shows, I wanted schools to be reopened as early as April of 2020. The issue was the fear and the issue was the safety issues. But COVID has really hurt in so many ways. But this has been a Republican talking point for a long time. And
it's not a Republican talking point. It's about improving education for the country. And they've been in charge for decades, and it's not working. So now it's time for reform. Finally, Trump has the stones to do it. Nobody else wanted to go after people like Randy, but people like Stephen Miller are fortunately spreading the truth and getting it done. So good stuff and good developments there. Now, let's carry on because we got a bunch more business to attend to here today. Pam Bondi announces the arrests and charges for multiple individuals who are, as we call them, Tesla terrorists. Now, are they going to be charged with terrorism, even though they're committing violence in the name of trying to shift public policy, in this case, Elon Musk, who is working with the government, and trying to intimidate and to cause fear for other people who might be driving Teslas, who might be concerned that if they go into the grocery store, they're going to come out and have their entire vehicle ignited with Molotov cocktails? Well, we'll see. But what has been announced are charges, and they're going against 3 individuals who are responsible for the violent destruction of Tesla properties. She posted this over at the official U.S. Department of Justice account on X today, saying, "The days of committing crimes without consequence have ended. And let this be a warning. If you join this wave of domestic terrorism against Tesla properties, the Department of Justice will put you behind bars." Attorney General Pamela Bondi with the announcement. Now, here's what the Department of Justice explained to us, saying that today, Attorney General Pamela Bondi announced charges against 3 individuals responsible for the violent destruction of Tesla properties. And we've seen multiple videos and photographs of it. The environmentalists care about Mother Nature unless it's a Tesla. If you ignite the Tesla, Mother Nature's happy with you because that smog is the remnants of fascism that you're burning into the air. And it knows that that CO2 is much different than the other CO2 that comes out from dirty Republicans. But here you can see, they continue, they say, all 3 defendants will face the full force of the law for using Molotov cocktails, incendiary devices, just set fire to Tesla cars and charging stations. Tons of damage, right? It's not just regular property damage. Like, let's say you're mad at somebody, you go smash their car windshield in or something like that. You're mad at an ex, right? I used to represent people like this. Someone's mad at an ex, so they smash their Xbox or something. Smash on the ground. He never loved me. He just played that damn game all the time. All right, smash it. All right, break the TV. It's $1,500 of damage. Okay, you get charged with whatever. Not terrorism. Okay, it's different than this. Different than going out with a weapon and lighting Molotov cocktails. These guys think that they're like Barack Obama supporters and that gang that they loved back then. They're in favor of this stuff. So they were lobbing Molotov cocktails. She says the days of committing crimes are over. All right, we're in charge. We're going to put you behind bars. Here's some details. One defendant was also armed with a suppressed AR-15 rifle, was arrested after throwing approximately 8 Molotov cocktails, 8, with an AR-15 at a Tesla dealership located in Salem, Oregon, which is blue as hell. Were there any January 6ers throwing Molotov cocktails anywhere? Anybody remember? I don't think so. We watched a lot of footage here. I don't think so. Did any of them show up with suppressed AR-15 rifles to the Capitol? No, they didn't. No, they didn't. Oh, interesting. Yeah. Here was another person. This was in Loveland, Colorado. After attempting to light Teslas on fire, again with Molotov cocktails, organized in collusion, a grand conspiracy happening across state lines in multiple locations with the same weapon, the same tactics and techniques. Was there possession of materials to produce additional incendiary weapons? This guy was dumb, though. Couldn't even light it. Colorado's a little cold, right? Maybe still snow up there, trying to get it going. Then in Charleston, South Carolina, a third defendant wrote a profane message against President Trump around Tesla charges before lighting the charging stations on fire with Molotov cocktails. 3 for 3, 3 weapons of the same variety, right? So same method and modality in 3 separate states. Sounds like a conspiracy across state lines. Hopefully they're investigating this to find out if there's commonality between them, what Telegram groups they were in. Because remember, they went into the Proud Boys Telegram groups, and there was a bunch of bravado and nonsense going on in Telegram groups, as they do in many chat groups, people just talking garbage all sorts of ways against each other. Doesn't necessarily indicate that you're going to go and engage in seditious conspiracy. But they made the case for the Proud Boys, remember, and they put them in prison. Some of them wanted 20 plus years for them. And those people didn't do anything of the sort, anything remotely like this. In fact, there was evidence that they were helping calm things down in the building. They certainly weren't throwing Molotov cocktails, right? They certainly weren't organizing property damage in 3 locations in 3 different states. So Pam Bondi, to be clear, has, I think, carte blanche to go and throw the book at them. What she has told us here is that each defendant faces serious charges carrying a minimum penalty of 5 years up to 20 years in prison. So what charge does that mean exactly? 5 years? You're not really getting 5 years for terrorism, but what you'll see is it's probably arson. So we'll see if the charges ultimately get dropped. And I forgot to mention, we haven't seen the charges yet. Normally we see them dropped right here at the bottom left. There are some names floating around about who these people are, but I haven't seen it officially confirmed yet. I'm waiting for the court documents. You know how we like to look at the documents here. So I haven't seen the charging documents yet. I did look them up on Pacer under a couple suspected names, but I did not see them as of today, which would be normal if they're filed today. We'll get them tomorrow. So I would expect if they're getting charged like right now, getting processed right now, we'll get them probably tomorrow. So they have been charged. Axios is telling us that there are more investigations underway. And this morning on the Membo stream, we saw clips from Bongino, or posts from Bongino rather, saying that they're looking into the swatting incidents and to the Tesla incidents, as they should, because they certainly seem to be connected. And those swatting incidents are also, I would argue, a part of a domestic terrorism operation if they're literally trying to get people killed by having SWAT teams show up at their houses. So the FBI is investigating. Axios has this, and this has been a Tesla takedown protest that is currently underway. Even Jasmine Crockett-Fulov is very excited about it. You know, her birthday's next week, and she wants Elon taken out, she said. Our teams are actively working on the Tesla incidents, wrote Bongino. Musk was shocked about this. The FBI is investigating this. A person was dressed in black approaching businesses in Vegas. That individual used the devices to set multiple Tesla vehicles on fire. One incendiary device was recovered inside a vehicle undetonated. Also believed he fired at least 3 rounds from a firearm at the vehicles. FBI is also working with ATF to investigate overnight incidents in Kansas City. Tesla takedown is a movement. It's a global one. Just like those maniacs who were supporting Luigi Mangione after he shot a CEO in the back when it was under the dark of night or the morning. So they're excited about this, the Tesla takedown. So Pam Bondi and others are coming in. Pam Bondi had a comment about this, very short clip from Colin Rugg, shared with us when she was on with Fox News and telling us that 20 years might be where this goes.
We have people we're locking up on that. We have someone in jail right now from one of the dealerships. They threw a Molotov cocktail through a dealership. They're looking at up to 20 years in prison. So if you're going to touch a Tesla, go to a dealership, do anything, you better watch out because we're coming after you.
Wow.
And
Well,
if you're funding this, we're coming after you.
Yes.
We're going to find out who you are.
Yeah, who is orchestrating this across multiple states? We definitely want to know. So is it going to be arson? Probably, based on what the penalty looks like, and it certainly fits. They say under U.S. code, it's a federal crime to damage or destroy by means of fire or explosive any property used in interstate, foreign commerce, or any activity affecting interstate or foreign commerce. Nuking Teslas, of course, would do that. Any person found guilty of arson under this statute may be sentenced to a max 20 years in jail, minimum 5 years. If it resulted in injury, goes up to 40 years, although I don't think anybody was actually injured. And we'll see where it goes. So we're looking for the ultimate charges. We want to see what they appear to be. And when they drop, we'll get them and we'll talk about them. So thanks for subscribing and joining as we do. Now, meanwhile, Elon Musk is striking back. He has been sued by the state. So not only are Democrats thrilled that his buildings are being torched or his vehicles smoldered into the ground, but they're also unhappy that Doge is coming in to make sure the government is not engaged in massive amounts of fraud. So what happens? States like New Mexico with Governor Lujan, who said that she could eliminate the Second Amendment via executive order and literally tried to do that. They're now suing, saying, Elon's violating the Constitution. What? Do you see what you people just did? Do you understand what you tried to do, Governor? No, she doesn't, because it's a capacity problem. But the District of Columbia is where this case is currently residing. We've got 31 pages here of delicious juiciness because this is a reply from the DOJ on behalf of Elon. He's being sued by New Mexico and New York and all the blue states. And Elon has filed a motion to dismiss. Now, this case is taking place in Judge Tanya Chutkan's courtroom, the same judge who has given us pretty bad rulings and was giddy at prosecuting Trump in the January 6th case when Jack Smith brought that case against him. And we just read a decision from her yesterday where she authorized, I believe it was the EPA funds to go back out. And she is sneaky as can be, concocted that. That, of course, was a contract cancellation problem. And she said, actually, it's a constitutional violation. It wasn't. It was a cancellation. And she wrapped it up into a constitutional pleading. But in this case, she's been very skeptical of the states because their pleadings have been so terrible. They're like, well, we're going to lose everything. Well, what are you going to lose? Well, something bad when it happens. Well, what's going to happen? We don't know. Okay, well, is it going to be imminent? Maybe. Okay, well, it needs to be more than maybe. But it will be bad. Well, how bad? We don't know. Okay. So Chutkan has been skeptical on this. And what we've seen from Elon is the following. He writes via the DOJ in response, their final reply, the final word before Chutkan decides. They say, all right, listen, Chutkan, the state's response goes a long way in narrowing the legal disputes. So they've changed their story. Lujan, the governor, the Second Amendment banner, they kind of shifted their arguments, you know. And so this should be immediately dismissed since they're so dumb. First, the states lack standing, right? In their response, they reduced their 60-page complaint to 3 theories of harm. So they file this big whiny complaint and they're like, well, why are you even here? And they're like, well, we got these 3 theories. All falter under the weight of the state's either own allegations or binding law. They say, well, there's one allegation. They say, well, a state university had its USAID grants canceled. Well, we got harmed. But their declarant admits those decisions came from USAID, not any defendant. So why are you suing Elon and Doge? Go sue USAID. You're suing the wrong party. So you can't even sue us here. So get out. Another state, another declarant, and you're seeing so many of these, it's honestly hilarious. I'm seeing all these dockets. We haven't read through a lot of them here because they're so stupid, but it's just like declaration after declaration. They're like sob story letters. Maybe we'll pull one up. But one declarant, he says his agency has had problems drawing on federal funds for unknown reasons. Like, I tried to access the portal and it got a 403 error. But that declarant similarly offers no connection between that difficulty and any of our acts. They're like, I don't know, did you try to clear your cookies, idiot? Like, it's not our problem. You can't log on to the internet and go to a browser, go to a website. Call your son. He can help you. And as for the actions contemplated by the parties actually named in this case, the state's arguments fare even worse. They object to what might follow and what might happen. We've already seen this, right, where they were mocking them. Oh, it could, and it's possible, and all this. Here you go. Possible agencies like the CFBP that are supposedly the targets of Doge. And they press the same data access concerns that have already been rejected in other courts. And regardless, they have nothing to do with the legal theories pressed here, all of which turn on the use of data and have nothing to do with its access. So they're suing to stop Doge from getting access, but they're coming up with speculative harms that are based on the use. Writing. Now, second, the states, Lujan and Tisch, they're also failing to state a claim. The states agree that their appointments clause claim, which is the argument that Elon should have been appointed to an office, right? Elon is too powerful. So he should have been in an office, like in an agency. And he's not. So he's usurping constitutional power. The response, of course, is Elon is just a consultant, essentially. There are Doge teams, but the Doge teams are reporting back up to the agency head who's making those decisions on their own. In other words, Rubio is making State Department and USAID decisions. Same with Scott Bessent at the Treasury. They say the question is about influence, but Elon has no formal authority. So they say, but he has to be an officer. Well, the answer to the question is obviously no, under binding precedent. The state's claims fail. They attempt to shoehorn their far-flung policy grievances into a constitutional challenge, right? Everybody everywhere has had their constitutional rights violated. Trump came in, suddenly everybody, right? You know, their email signatures and stuff. My constitutional right to put my pronouns in there. Okay, well, then you don't have a constitutional right to work here, so get out. Yes, I do. But while placed within the four corners of the complaint, they're not even moored in law. This suit is baseless and it should be dismissed. Okay, we've seen they don't have standing. Elon responds. They're abandoning their argument that they need not allege an actual injury. They say, we don't even need an injury. They fail to identify any injury that's traceable to Trump or that this court can redress. They're talking about university contracts and how agencies might cause hypothetical harm to their programs, but it's all hypothetical. Nobody's done anything yet to the states. The federal employees have gained access to certain data. They say, okay, well, it could be a data risk, but none of that is actual injury that would create standing. So they clarify, and it shows, Your Honor, just how little they can muster to show any actual harms. They filed this complaint. Their original complaint was 60 pages with 277 paragraphs. And in it, the allegations of any actual financial injury just boil down to two assertions. Okay, so it's a bunch of screeching and whining, but the only two specific injuries are here. First, they say USAID suspended certain grants to Washington State. Okay. And second, they point to a loan declaration from some random dude agency. He said, I couldn't figure out how to use the internet. Okay. Now, these allegations are not linked to us. State Department canceled USAID. Talk to them, sue them. And if that dude in New Mexico couldn't figure out how to use the browser, get him an IT person. The states here do not allege that any identified defendant in this lawsuit directed USAID to suspend anything. So what are you suing us for? They even admit USAID canceled it. Leslie said that in her declaration. Saying in response, the state says, well, that DOJ directed the agency to cancel. But their complaint doesn't support this claim. You can't just file a lawsuit and then change everything and make that your argument. Like, it's got to match the original complaint, or you got to go back and amend it. In fact, the only paragraph that discusses these alleged suspensions, which is paragraph 231, cites to the paragraphs of another declaration from Brunel, and Brunel is saying that the USAID or the award recipients were responsible for this. Okay, so it's not DOJ, so you can't sue us. They admit it, and in their complaints and their declarations, they've got the wrong people. Now, nor did the states, and these are from the states, like this is not some random plaintiffs. These are a whole slew of state attorneys general who are coming in on this, from Lujan to Tisch and many more. Now, nor did the state's allegations about other USAID contract suspensions suffice, saying, well, you canceled this contract and this contract. The states say that Elon, but he said we were going to put everything into the wood chipper. USAID is going into the wood chipper. We're like, yeah, perfect. But that comment does not refer to the USAID contracts at all, let alone any specific cancellation that harmed the states without proper approval. Now, and we're talking about the contracts, right? Shredding the contracts, obviously. Now, the one USAID action the states allege was taken by DOJ was in response to Jeremy Lewin in an email. But even assuming this proposition that the university contracts were within the scope of the programs abroad that were canceled, the email at issue confirms that the USAID officials had already approved it. So your own people say that other entities approved it, and you can't sue us for that. Even this New Mexico guy said, I couldn't get my money. There are no allegations about that in the complaint. So it's in a declaration, but it's not in the complaint. So you shouldn't link us to that. They should figure out how that guy can use a computer. Now, they also say, the states say, okay, look, here's where the actual harm is. We might have to change our programs because there could be future harms. Like, we have to change now in anticipation of the future. But there's nothing that amounts to any impending harm under any of these standards. Each of the alleged future harms would only occur if agencies take certain actions they may never take. And so it's just not imminent enough. It's not a harm that counts for TROs or preliminary injunctions. Their claims are deficient. Their theory of injury, that the decrease of certain enforcement efforts will cause consumers with complaints to come complain to us. If you get rid of Elizabeth Warren's agency, then people can't complain to them. Then they're going to complain to us. That's going to harm us. They say, okay, that's not the type of harm that any of this is for. You can't just hamstring federal policy because the state might have to do some work, right? Policies change all the time and states adapt. And the data access complaint from the states also fails. Although the states continue to use the label unauthorized, they keep saying it's unauthorized. It is authorized. None of the data has been transferred to anybody outside the government. They don't even want to talk about it. They just keep talking about this substantial risk of disclosure. But their reliance on these decisions is misplaced. The states do not dispute that their own declarants characterize the potential risk as speculative. Even their own witnesses are saying, well, it could happen. And the states are not even trying to explain how this injury, which is improper data access, is even linked to their legal theories. Trump, even if they were exercising unlawful power, and to be clear, they're not, none of that is implicated by data. That is because that DOJ have been granted access by those with uncontested authority. So it's access. Their gripe is about access, but it's really about use. So they have to point to some use of this power, and there has been no use that is problematic. So they're failing to state a claim. There is no appointments problem because they even expressly admit Elon does not occupy an office of the United States, right? Their argument is he should. Presidential advisors do not wield significant authority that requires confirmation under the appointments clause. And so because they're even admitting he's not in an office, they have to dismiss this. They failed to say he's in an office, and since there is no office, they can't bring a claim under the Appointments Clause. We'll fast forward through this one a little bit and say, well, even if, because the argument is Elon is not in an office, but he's functionally acting like an office head. So they respond, the DOJ, on behalf of Elon, saying, we've demonstrated that other circuit district decisions foreclose the state's Appointments Clause claim. There's a binding case saying there is no injury at the hands of an official who exercised power in violation of the Appointments Clause, which is really the holding that looks like it came out after a RIF lawsuit. Saying, as this demonstrates, their emphasis on whether the planning of the RIF was instituted by officials has no bearing on that other decision. And so they can't distinguish that case. So they cannot controvert that they suffered no injury at the hands of an official who exercised power in violation of the Appointments Clause. In other words, Elon cannot be blamed for the harm that's not tied to an official office under an Appointments Clause claim. Maybe there's another claim. But the states also acknowledge that Musk is a special government employee, right? So they're even saying, well, you acknowledge he's officially a part of this. But they say, but he's not a mere advisor. He's got too much influence. But they acknowledge in their complaint, they say, well, he's a special government employee. And as such, he's been brought on for certain duties. So how can they complain that he's not in an office if he is a special government employee, right? They just say he's in the wrong seat, essentially. The complaint further says he's an advisor. So their attempt to disclaim their allegations is concerning, right? He's saying, I don't understand what they're doing. They know he's in one position, but they're suing because he's not in the other position they think he should be in. So they're admitting he's not in that position and then suing under that claim, but they can't bring that type of claim here. The states nevertheless claim it's going beyond. And he doesn't occupy a continuing office, and so they can't escape their own complaint. It's fatal. They say Doge is a continuing organization, but that's beside the point. They say Mr. Musk does not occupy an office, and they express concern about his authority as an individual. But that is not a claim, because that role would not and will not continue if the person changed. The states don't have a claim here. So then they next turn to another argument. They say this is outside the law, right? The Doge is working outside the law. It's not allowed to do what it's doing. And they say, if you're going to bring a claim under this, you better meet pretty high standards. One, there is no express statutory preclusion of all judicial review and other elements. But this is a very demanding standard. And this has already been rejected in other cases. And so you're not entitled to relief here. The statute defines a temporary organization. Trump issued an executive order. Everything we've done here is above board and actually under the law. So you can't say it's outside the law. It's not ultra virus. Now, on the law, the state's exclusive argument then turns to a major questions doctrine. But the question, they assume this applies to a claim like this. The president has historically wielded the authority under this to establish what he's done, and he's done that here. And finally, in their opposition brief, they then invoke the special government employee statute. But all of that fails. The states do not and cannot plausibly assert that any of that has any application to Musk or to Trump. So that fails too. So all of this should be dismissed. They even tried to bring an Appointments Clause claim against the president. The states cannot establish standing to sue President Trump based on Musk and the Appointments Clause. The states assert that they are harmed because Trump improperly delegated authority to Musk. But the harm the states claim derives from the actions allegedly taken by Musk, not the president. And so they can't get an injunction against the president. Finally, what they're relying on is misplaced. The DC Circuit explained in this other case that because the states are seeking injunctions against Musk, the states have no legal basis to get an injunction or a declaration against Trump. It's going against Musk, not Trump. He's the president. Musk is not. So therefore, the state's complaint should be dismissed. very substantive motion there filed by Jacob Seiler, who is representing the civil division over in Washington, D.C. on behalf of Elon Musk. So that is the final reply. It's going to go over to Judge Chutkan. Remember, the states are essentially asking that Doge and Elon be precluded from doing anything that they're doing. It was a very broad order. And the last time we heard from Chutkan, she was skeptical on this. So we'll see if that skepticism remains. But Chutkan is one of a number of Democrat judges who've been installed by the Democrats to dictate policy when they want to get their way, ruling from the bench. Here is a clip from Libs of TikTok explaining to us that Chuck Schumer is saying the quiet part out loud and admitting what we all know they're doing.
There are those who believe that we are in real time living through an assault on the constitutional order. Do you believe that we are in a constitutional crisis right now?
Yes, our democracy is at risk because Donald Trump shows that he wishes to violate the laws in many, many different ways. The good news here is...
Name one. And are they tired of saying that line? They need new material. He's been saying that same stupid line for years. And the democracy marches on?
We did put 235 judges, progressive judges, judges not under the control of Trump last year on the bench, and they are ruling against Trump time after time after time. And we hope that the appellate courts, when it gets up there, and the Supreme Court will uphold those rulings. They restored the money to NIH. They required that 8,000 federal employees have to come back.
Illegal.
We're in over 100 lawsuits against them, and we are having a good deal of success. It's only at the lower court level right now.
And the Democrats had been plotting this for quite some time, and the useless Republicans in the Senate gifted them a bunch of extra seats. We covered that here at length. And if you remember, what happened was the Republicans were saying, well, we're going to give you these lower level seats if you give us some of the Court of Appeals seats. Then the Court of Appeals judges said that they would resign. Then Trump won. Then they undid their resignations, their retirements. So they came back. So the Republicans gave them all the lower benches and then didn't even get the Court of Appeals judges in response. And people are like, well, Mitch McConnell's a genius Senate leader. Okay. So that didn't really work out for us. But their plan is to insurrect the country via federal judges. And then they're going to call that democracy because they're doing it in dark robes. We're going to keep our eye on this case. Thanks for subscribing and joining as we do. All right. Now, a couple of short updates on these cases. This one, also out of D.C. The prisoners are going back. Judge Roy C. Lamberth, who we've talked about here before on the channel, just issued another order reversing a Trump executive order. This one came down, District of Columbia. You can see it's the Jane Doe case, but you got to be careful about Jane's, probably more like John. But anyways, it is against Pamela Bondi at the DOJ, and this is in reaction to the trans prisoners who were shifted from one side to the other. The judge is saying, ship them back and misalign the genitals again or something. It's very confusing to keep track of these, so we don't spend much effort on it. But here on February 18th, this is from Judge Royce. Well, this court entered a preliminary injunction enjoining Trump's executive order. Trump said, all right, listen, dudes over here, chicks over there. Like, that's it. Just, you know where to go. It issued an executive order against the group of transgender women, we'll just use the terms loosely, on Eighth Amendment grounds. Okay? So, Executive Order 14168. And Trump didn't issue it against them, but the judge is precluding it as to these John Does. Now, on February 21st, the plaintiffs, the Does, filed a motion to extend that preliminary injunction to a group of additional plaintiffs. Okay, so the Does come in. They're like, well, we want all the Does to join us for unity, which the court granted on February 24th. So basically made it, I don't know if those people joined officially as plaintiffs in the lawsuit or what happened, or if the judge just granted it to everybody and essentially certified a class just like Boasberg did for the deportees. So the judge writes, on March 14th, the plaintiffs, the Does, moved with the consent of the defendants, so Trump, to file a second amended complaint. The second complaint is substantially identical to the first amended complaint, except it adds two other people, Rachel Doe and Ellen Doe. So, okay. Now, the new plaintiffs are in most respects, it's weird. This is kind of, it's like you're using pseudonyms, but you got to use first names to make sure we know that they're female, even though they're biologically not. Like, why don't you just call them two additional plaintiffs? Like, why do you need to put them in there? Anyways, so just to keep track, I guess, of who they are. Anyways, so the new plaintiffs are in most respects similarly situated to the other plaintiffs, with one exception. While the other plaintiffs were pending transfer to a male penitentiary, so the Johns go back to the John penitentiary, when the court ruled on their motions for an injunction, these new plaintiffs have already been transferred to the male facilities. So Rachel became Roy and Ellen became Luke and got transferred back to the prisons. So then the plaintiffs have now moved for a preliminary injunction, the Does again, to stop the executive order against them and to have them returned back to the female prison facilities to be called Rachel and Ellen again. So the motion then repeats the previous arguments against Trump's order, but adds new factual grounds for new claims which arise. Here's what the new horror show is. First, the Does allege that the Bureau has already halted Rachel Doe's hormone therapy. So Rachel was going back into Roy, unlike the earlier plaintiffs who were only threatened with this discontinuation of their therapy. So then second, the new plaintiffs allege that they have actually been subjected to sexual harassment at their new facilities. Of course they have. So then third, the new plaintiffs allege that since their transfer to a male facility, they have been unable to access bras and women's underwear because it's a male facility, you know. And fourth and finally, and that's like a constitutional violation right there for sure. Yeah, cruel and unusual punishment, I know. Fourth and finally, the new plaintiffs allege that they have been subject to strip searches by male prisoners without female officials present. In a sealed response, they contest each of these new claims, and so the court need not dwell on these arguments at this time because it's judged like this is disgusting. But even supposing that they are correct, Trump, that each plaintiff's new argument is either factually or legally defunct. Okay, well, so what? They don't get bras. They're not entitled to bras and panties of women panties. Okay, no. The new plaintiffs are at least as strongly situated in terms of their Eighth Amendment claims as the existing plaintiffs. Yeah, cruel and unusual. Moreover, the fact that they have already been transferred and allegedly they've been abused by not getting women's panties, they can only strengthen their claims of irreparable harm. The final two prongs of the preliminary injunction analysis, which is the balance of the equities and the public interest, are at least unchanged, and it's in the public interest to have biological men in women's prisons. Yeah, I guess that's in the public interest, says the judge. So therefore, the court is satisfied that the relief is appropriate for the two new plaintiffs for the same reasons as the others. And the court determines that it is appropriate in this case to enter an injunction against the government. The government has communicated that there's another form of relief here. In accordance with this Litigation Reform Act, I can remedy this violation, and this is the least intrusive means for me to do this. And the court has considered any adverse impact on public safety in the criminal justice system. And there's no impact on public safety. There's no impact on the operation of the justice system. So they can go back to their trans identities across the facilities, and the women in the women's facilities can just eat it. So therefore, upon consideration of the plaintiffs and the entire record herein, here it is granted. So the trans going back, and Rachel and Ellen can continue to be Rachel and Ellen rather than Roy and Luke. And they're ordered to immediately transfer them back to women's penitentiaries to go hang with the ladies over there. and to continue their gender dysphoria treatment at the cost of the American taxpayer, which it ain't cheap. So signed there by Royce C. Lamberth, and we'll see what Trump does in response to that. So far, haven't seen a notice of appeal, although that order is fresh out of the oven. So we'll keep our eye on that one. Thanks for subscribing and joining as we do. Now, another very quick update here. And this was another good one from Pam Bondi. Pam Bondi telling the courts they've done enough. They're not going to be allowing the Perkins Coie Democrat hack lawyers back into the federal government. We know that this is a case brought by the lawyers against the DOJ in response to Trump's executive order, which essentially blacklisted them from the federal government. The law firm was Perkins Coie, and it was Mark Elias and Michael Sussman, in my opinion, corrupt Democrat operative hacks who were working with Hillary Clinton, Fusion GPS, Michael Steele, trying to collude to set Trump up with the Russian collusion scheme, selling it to the FBI, selling it to the media. It was all fake. So Trump, of course, didn't forget about that, neither did we, and banned them from everything. The case ended up in front of Judge Beryl Howell, another terrible judge who has hated Trump for a decade now, and violated his attorney-client privilege in my reading of what she did. But she heard this case and she granted an order saying, we're going to give Perkins Coie some of their privileges back. Trump said, you're cut out from the buildings, you're not getting paid, contracts are canceled, and your parking passes are rescinded, and you're banned, right? And all the things. And she said, well, these can come back, and the specifics don't really matter. But what has happened is Pamela Bondi has given them a couple status reports and updates. And in that report, Bondi is explaining, we've done everything we're going to do. And if you don't like it, well, you can eat it. So we got 3 different updates here. And let's go through them one by one. First was a status update to the court. Perkins Coie is the case. The court is getting this from the DOJ, Deputy Associate Attorney Generals. We've got Terry and Richard Lawson, Terry Henry and Richard Lawson. Here's what they sent in to Judge Beryl Howell. They said, hey, Judge, all right, listen, on March 19th, the court entered a minute order directing the U.S. government, Bondi and Russell Vought and others, to immediately issue guidance to all other agencies, directing them to immediately to do this, to communicate to every recipient of a request for disclosure of any recipient with Perkins Coie that their request is rescinded. Okay, so in other words, the executive order went out. All the agencies said, cancel the things. The judge says, undo your cancels. Okay, so like retract those emails. That's one. So the judge is saying, okay, or the DOJ is saying, okay. And also cease making requests for disclosure until further order of the court. Now, the court's minute order also required them to file a status report by noon today about what we're doing. So we're doing that. So here we are filing this report. So the minute order was issued at 9:43 from Judge Beryl Howell, telling us in response to a motion to clarify. And so the minute order was issued without the benefit of a response by the defendant. So in other words, Perkins Coie submitted a motion to clarify. The judge clarified, but the defense didn't have an opportunity to even be heard. Now, we have worked diligently. Okay, you told us to basically shove Perkins Coie back in. We've worked diligently to implement your minute entry, Judge. But there have been significant logistical difficulties in coordinating joint Department of Justice and OMB budget guidance issued by the AG and the director of OMB by both agencies, their principals and representatives. So you see what this paragraph is, as well as then distributing the guidance through the appropriate process involved to ensure the guidance is issued to all agencies as directed by the court's minute order. Outstanding paragraph, whoever wrote that. It's one giant run-on sentence, and nobody knows what it says, not even the person who wrote it. Definitely not the judge. You can get the sense of what they're talking about, but like in practice, this is like nothing is going to get done. Okay, it just means there's about 50 million speed bumps. Whoa, yeah, no, we're definitely going to get Perkins Coie back in here. Yeah, I mean, so our first step is we're just going to work out the logistical difficulties. And the way that we're going to work out these logistical difficulties is we got to set up a joint meeting so that we can coordinate between the Justice Department and the OMB, right? Because we're going to have to talk about budget guidance on this. So schedule that joint meeting and get the budget experts in this meeting, because we're going to have logistical difficulties with Perkins Coie. So get that meeting scheduled. And you're like, wow, when is that going to happen? When is that ever going to get done? Never. Issued by the Attorney General. We got to consolidate between the agencies. And also, it's not just these two people, all the principals and the representatives of these two agencies. And then we're going to have to distribute it once we have these meetings. And it's not going to just be one meeting. I mean, you never get anything done in one meeting. It's going to take like probably a month to even, you need a meeting to schedule all of the other meetings that you're going to need to figure this out. And then once you get it, then you have to distribute the guidance through everybody. And there's an administrative process that's involved. Like once the guidance comes out, you can't just like email that to everybody, obviously. You know, oh, Perkins Coie comes back just via email to everybody? No, obviously you can't do that. It's got to go through revisions and people have to stamp it and approve it and all these processes. It's a bureaucracy. You guys built it. We are following your rules so that we can ensure that it's issued to all agencies as directed by your order. Okay. We're going to do exactly what you said. It's tactical compliance. It's over compliance. It's the same strategy that we've been talking about here. It's right here. It's a beautiful paragraph. And it's the same strategy as the I forgot to sign the check strategy. Oh, no, we'll get you paid all right. Check's in the mail. Oh, I forgot to sign it. Oh, it's a bummer. I'll send you another one. It's the same thing. So we're going to do it, but we have to do it right. You wouldn't want us to break the law and like violate the agency process, right? So the joint OMB, and so just be clear, like as the judges come back and they say, hire Perkins Coie back, and the judge is going to be pissed about this, but when she is, the only thing, like if you're a manager of a company or you manage a team or you're some leadership position, like you got to get in there and get granular with people. Like, did you do this? Somebody's misperforming did you do this today? You're on probation. I'm coming back here tomorrow to make sure you're at your desk at this time. The judge can't do that. She's going to have to do that in order to make this stuff happen, right? That's the power of the executive branch. So a lot of these orders are very scary on their faces, but practically, you can't force the executive branch to do things. They execute the things. So the judge, they can hem and haw, whine and moan all they want, but this is what the process is going to be, okay? And this is like a beautiful, beautiful paragraph to illustrate exactly what's happening behind the scenes. So the joint guidance required by the court's order, using all the specific language called for in the minute entry, it was distributed to all agencies via the OMB process for all agency issues a short time ago, okay? So by contrast, we did send your minute order out. So we also did email it to everybody and just said, hey, here's the minute entry. So we complied with you. We tactically complied with you. But in order to actually implement it, like we notified everybody. And by the way, so this is like beautiful. You said here, communicate to every recipient. So we did. We communicated it. We sent your stupid minute entry to everybody. They all got the email. Judge Beryl Howell says, duh, duh, duh. So we sent it to them. But implementing this, yeah. We're working on it. We're working hard. We have to have a joint agency, interagency meeting between the joints, between everybody, the OMB and everybody else. And we're going to bring them together. We're going to work real hard on that. So we recognize that this status report is filed several minutes beyond noon at the request of the court's indulgence in this matter. Sorry, we're a little late on this. Counsel for Trump were able to confirm with OMB that the guidance required by the court's minute order was distributed at noon. Like, sorry, we're a couple minutes late, but we just got notified. We emailed everybody your pathetic order with this status report filed as soon as we were done. So we had no choice, but we got it to you by your deadline. Then they sent in another supplement. And they said here, also as a follow-up to our supplement, we also filed the status report saying that we did send the minute order out. Now, due to the timing of the distribution, as explained in the report, the final guidance as distributed was not available to counsel for the defendants prior to filing this. So now we've sent this. Here's a memo for all agencies related to Trump's executive order. It's now attached, and so we sent it out. Here it is, Judge, right? It's tactical compliance. We did exactly what you told us to do. It says, everybody, see attached a joint guidance from the DOJ and the OMB regarding a court order. That's it. Send it out. Here you go. And noting, if you have any questions, contact us. So we did what you asked us to do, Judge. We're in compliance, but don't think that they're coming back in. All right, they're not. And what Pam said in follow-up to all of this is the beautiful memo that looks like this. Here's the attachment. Here's the memo. Court order regarding Executive Order 14230. They wrote this to everybody. From Bondi and Vought, subject court order memo for all agencies. Here's what they communicated. On March 19th, a district judge entered an order in Perkins Coie. The case involves a challenge to Trump's executive order, which was, of course, addressing the risks of the hacks at Perkins Coie. Now, all agencies, they write, pursuant to this order of the judge, all agencies subject to Trump's order must, communicate to every recipient, basically copying and pasting the judge's order right here, must communicate to every recipient a request for disclosure of any relationship with Perkins Coie or any person associated with this, that such request is rescinded until further notice. So if you're just a random person, you're just like, what? All right. And must cease making such requests for disclosure pursuant to Section 3A of the order until further order of the court. Like, all right. But the executive branch's position, so like this is where Pam is getting aggressive and we like to see it. Hey, Judge, I did everything you told me to do. You said communicate to everybody this, and I did. Copy and paste it. Here you go. But guess what? Here's my position. The executive branch's position is that executive order from Trump 14230 is permissible and that the court's order was erroneous. So the government reserves the right to take all necessary and legal actions in response to the dishonest and dangerous conduct of Perkins Coie as set forth in Trump's EO. So there you go, Judge. In other words, we're in total compliance with what you said to do. Everybody got your little stupid memo. We sent it out. But they also got our position on this, which is you're wrong. And we're going to take every legal action, which of course includes appealing this and getting a higher court to show that this judge is usurping the power of the executive branch away from them. And we're not changing. So you may get a memo on this, disclose this, and blah, 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 but we're still calling them dishonest and dangerous. The culture at the DOJ, at the FBI, is these lawyers are not welcome here. And Trump's order will be enforced to the maximum extent possible. And meanwhile, they'll just tactically comply with the judge. So shout out to Pam Bondi for that one. And we'll see what Judge Beryl Howell does in response. All right. And now, my friends, we've got one final update on the day, and it's quite a big one. And so let's get this puppy queued up. Yes. All right. Judge Boasberg, the deportation judge, is not happy. He gave several deadlines to President Trump, and Trump is fighting back. He's taking this up to the Court of Appeals to have them opine on the issue in front of this judge specifically, but he's also doing an end run around this judge and going to the Court of Appeals requesting a petition for a writ of mandamus. And so we're going to go through both of these updates here because the judge set a new deadline for Trump, which is tomorrow, I believe. We're going to come back on that to be clear. But here is what the judge wrote today. Not happy. Said, on March 18th, the court ordered Trump to provide by noon the following day specific information about the flights carrying the Tren de Aragua terrorists out of the country. The judge says, I issued a TRO, and then you flew them out of here. But Trump instead filed a pleading shortly before the deadline, which was yesterday, to seek to stay the order in large part on the ground that they were considering whether Trump was going to invoke the state's secrets privilege. Now, although the judge writes, Boasberg, although skeptical of the applicability of that privilege to this case, the court granted them another 24 hours to either release the information that was ordered, which were all the specifics about the flights, who was on it, when to go, who gave the orders, and more, or to invoke the privilege. We covered this at length yesterday. But then, In an ex parte pleading, so delivered right to the court and delivered shortly after today's deadline, the government again evaded its obligations. Now, it's ex parte, so we didn't see this submission, but the judge tells us. Here's what he got. It submitted a 6-paragraph declaration from the acting field office director from ICE, and the contents of which the government has informed the court may be disclosed. But after 4 paragraphs of identifying information, so this guy's like, oh, hi, he writes this memo. The judge wants a memo, all right? How many pages does it have to be? 5, all right. Can I do 4 pages for my introductory paragraph? My grade school teacher wouldn't be happy with me, but let's do it. So it does. Okay, hi, my name is so-and-so. I'm the director, removal, Harlington. My background and training is the following. I was born in 1965, and after a long term of high school, I was a little bit confused about what I wanted to do with my life, but I found a mentor, and it goes on for 5 pages. He trained me in the foothills of the Himalayas, and then finally came back, and I work at ICE. I was like, okay. Judge writes, on March 15th, he gave us the same information after all of that. It's the same stuff we already knew. He said on March 15th, 2 flights carrying aliens being removed under the Alien Enemies Act departed U.S. airspace before the court's minute order of 7:25 and before the court's oral statements during the hearing. He's like, oh, you want a statement? Here you go. Shout out to Robert L. Cerna. He then stated, I understand, and the judge is not happy about that, I understand that cabinet secretaries are currently actively considering whether to invoke the state secrets privilege over the other facts requested by the court's order. Doing so is a serious matter that requires careful consideration of national security and foreign relations, and it cannot properly be undertaken in just 24 hours. So the judge says, oh man, this is woefully insufficient. He's mad. I ordered answers. He says, to begin, the government cannot proffer a regional ICE official, Robert, to testify to cabinet-level discussions of the state's secret privilege. Indeed, his declaration on that point is based solely on his unsubstantiated understanding. He's like, you gave me somebody who doesn't know anything about this. Now, although its skepticism concerning the suitability of this privilege was expressed yesterday and it remains, the court, at a minimum, requires an official with direct involvement to swear that deliberations of the privilege's invocation are ongoing at the level that Robert Cerna attests to. It further expects that such deliberations to be concluded by March 25th, which only exceedingly good cause may excuse. So we do have a deadline by tomorrow, telling us, in addition, to avoid further delay, the court will require Trump to show cause. Oh, that's like you're getting called to the principal's office, man. You're busted. You have to show cause on the facts that they have already disclosed as to why the failure to return these class members aboard the 2 earliest planes did not violate our TRO. Wow. So why didn't you bring them back? Not only I see how he could be writing this. Why didn't you bring them on the 2 earliest planes? Is he saying that they should have been turned around in the air, or after they landed, they should have been brought back? Why didn't they violate it? Okay, so the judge was doing an inquiry first. He was doing a fact-finding evidentiary hearing. Then he ordered a response. They didn't give him the response that he wanted. So now this is the next level. It's an escalation. Order to show cause. If you can't, if you can't satisfy the judge, the next step is contempt or sanctions, right? You're held in contempt, or you're sanctioned because you violated the court orders. Further supplementation may be required, but the court accordingly orders by tomorrow, March 21 at 10 a.m., Trump shall submit a sworn declaration, or his cabinet, by a person with direct involvement in the cabinet level discussions regarding the invocation of state secrets. So on my desk by tomorrow. And by March 25, the Trump administration shall submit a declaration indicating whether or not the government is invoking the privilege. So there are discussions, then an answer. And you shall file a brief showing cause why they did not violate my order. Okay, I think you did. You need to come show me why you didn't by failing to return the class members on the 2 earliest planes that departed on March 15th. So why did you not bring them back? And the gangbang ACLU lover lawyers who love representing terrorist gangbangers are ordered to file a response by March 31st, 2025, as to why they love gangbangers so much. And the judge, James Boasberg, of course, signed off on that one. Now, this judge is a hack. We've seen this before. He was also somebody who played a key role in the Trump-Russia FISA saga. Same judge who's blocking the Trump efforts to deport these folks is the same one that was nominated by Barack Obama. His role was the head of the FISA court. He made a number of decisive decisions, including a slap on the wrist for the Crossfire Hurricane team, the appointment of officials who defended the FBI during the Russiagate scam, and the renewal of the FISA powers. And so this judge is going after him. And we know what it's all about. Not justice, it's about politics. But Trump is not lying down. They have submitted from the Trump administration a petition for a writ of mandamus, going around this judge saying he is violating his authority and that the United States Court of Appeals for the District of Columbia should step in and do something. So from Trump's DOJ going to the Court of Appeals, explaining that Judge Boasberg is acting out of line. And here's what they write. All right, guys, Court of Appeals. Pursuant to the All Writs Act, the government respectfully asks this court to issue a writ of mandamus. So we're asking you to order Judge Boasberg to quash the district court's order, which is the discovery order, which says, tell me who was on the plane, who made the decisions, and more, which permits this court to take broad, intrusive, and unnecessary discovery into the activities of the president and senior advisor Elon Musk. Now, the government also additionally asks this court, what case is this? Let me make sure we're on the right case here. This is it's another petition. We're going to continue to read it. It's a petition. It's not related to the deportation case. So I got my cases mixed up, but this is another good one. So we'll read it. So this is the Doge case. So they're going around to get Doge back in service, not the other deportation case with Boasberg. So there is an appeal with Boasberg also happening right now. It is this document. We're just on the wrong document. So this is in reply. This is another appeal in the Court of Appeals on the deportation case, but we're going to go with this one for now. It's another appeal. It's another petition. Same people who are part of the Democratic Party who are trying to stop Trump, Doge, and Elon. So they say the government additionally asks for a stay before discovery would be due. Now, the district court is ordering discovery from Elon and Doge. It's unusual, it's highly invasive, and the Supreme Court has already made clear that senior advisors and discovery directed at senior advisors to go get information against Elon is the rarest thing that should happen. It should only happen when strictly necessary. And the court also rejected views based on the idea that you're intruding into the executive branch. Now, the district court's order flouts these principles at every turn. Rather than allowing discovery as a last resort, they're allowing discovery now, before anything has even happened, before even resolving the government's motion to dismiss. And so, as the government explained, discovery is irrelevant to their claims. Here's the claim. It's a violation of the Appointments Clause, is the allegation, and they're having this theory that Doge and Mr. Musk are directing the agency actions, but that's not what happened at all. In fact, the Appointments Clause issue is about Appointments Clause office holders. It's not about people with de facto influence, not control, over certain offices. So they're bringing their claim under the wrong provision. The district court brushed aside our concerns. And the threat to the executive branch is substantial here. They vaguely word their request, but all it's doing is burdening the White House. And so for that reason, the Court of Appeals should exercise its mandamus authority to stop the prevention of DOJ from doing its job. Now, the order states that DOJ is led by an administrator who reports to the chief of staff. Executive order came out. The parties agree that Musk does not occupy an office. He's a presidential advisor and special government employee. Now, a collection of states, so this is the states case, brought this against Elon and DOJ. Based on their theories, they've moved for a TRO. The district court denied the TRO on the ground that there was no irreparable harm. But then they filed a motion for discovery, and that was granted. So they want all this information from DOJ. Anything they've created, compiled, or edited, the production of all documents about DOJ, broad interrogatories, a request for anything that Elon said, and more. Now, this is a problem because you can't go and subpoena the president, a co-equal branch of government, to validate their work. But the district court granted that, granted expedited discovery, and the judge says that they want expeditious resolution here. So in finding discovery to be necessary, the court declined to even address Trump's position, the government's position. The court acknowledged the government had made standing and merits arguments and recognized the unusual timing of discovery, but it adopted their demands basically in full, saying that the court changed the production deadline and approved it. So the Court of Appeals then, writes the Trump DOJ, should exercise its mandamus authority and block the discovery order against Elon and DOJ. It is a clear abuse of discretion. It violates precedent. The Supreme Court has already made clear that requesting discovery raises the prospect of a constitutional confrontation between the executive and the judicial branches. If the courts are authorizing the inquiries into the branch when the branch is doing its proper duties, that creates a constitutional conflict, not Trump. Give us another case from Cheney. The Supreme Court made a decision in that one. And in it, the court expressly rejected the view that the White House could adequately safeguard its privilege over specific documents. The court vacated the denial of mandamus and instructed the courts to be sensitive to requests by the government for interlocutory appeals. And so what the lower level court is doing here is making the same mistakes. And so the district court ignored the constitutional burdens. There should be judicial deference that's afforded to the office of the presidency. The district court stated that discovery is burdensome, but then approved it. Now, the treatment of the burdens on the White House is irreconcilable with the prior precedent. And other case decisions have rejected the same rationale used by the lower level court, explaining that the reliance on the fact that Musk is not the DOJ administrator is similarly hard to understand. Musk is a close advisor who conducts briefings in the Oval Office. The other factors that they relied on only highlight similarities that support our argument. And so the discovery order is unjustified. In fact, they're seeking stuff that is immaterial to their lawsuit. Several categories have nothing to even do with anything that we're doing. They want planning information on what DOJ is going to do. It doesn't have any relevance to their claims. They can't go find new claims here. The purpose of discovery is to show what has happened, not to conduct a fishing expedition, which is all they're trying to do. And their request for details and names is not only intrusive, but plainly irrelevant to the merits of their claim. They say Elon is improperly appointed, but the information they seek doesn't go anywhere to an appointments clause. Their own concessions confirm no discovery is needed. They don't need to figure out where Elon Musk is appointed because everyone agrees he's not appointed to anything. He has no formal government authority at all. That is the end of the analysis. They allege a bunch of other things, but there is nothing else. The decisions in other cases also support our take. such results would suggest that influential White House advisors hold offices. And then people would just make up offices for people who are influential. That's not how that works. So asking for discovery here is not necessary to ascertain the disagreements. We already know what the disagreements are. And the district court didn't even consider other alternative avenues. They don't need to get information from us. Plenty of other places where they can figure out what DOJ is doing without intruding onto a co-equal branch of government. Now, the district court should have given this argument more consideration, but just said, we're going to benefit from briefing, and I'd like discovery so I can help decide. But they don't even have jurisdiction. Their lawsuit depends on a theory that conflates influence versus authority. And so they're missing the whole picture. And the prospect that they will fail is also likely. But the district court didn't care, just said, I don't know if they're going to fail or not. Let's have discovery. It's grievously overbroad, by the way. Everything they're asking for, FAQs, scripts, lists, charts, summaries, memoranda, everything. They also want interrogatories. They want to sit down and interview every single person working with DOJ, harassing government employees for doing their job. They want anyone who has worked with Musk, worked with DOJ, access or plan to access, the purpose of those access. This is everything under the sky that they're requesting for. And the breadth of this creates onerous ambiguities for the executive branch. You're forcing us to do a bunch of other things that is a clear intrusion into our privileges and into our constitutional mandates. The court revised the request and made other adjustments to that, but that doesn't mitigate this at all. In short, the court's discovery order flouts well-established principles governing litigation with the office of the president. It doesn't give us any benefit, and this is a generic appointments clause allegation that should be dealt with by you guys. And so this court should order and should grant a petition and grant a stay of the discovery order pending a resolution of this petition as requested in the stay motion. So a little bit of confusion there on my end. Apologies for that on what case we were reading. But that is obviously another case that they're taking up on appeal. But they're also appealing the Boasberg decision, which is this filing here. So Trump's team submitted a reply in the Boasberg case, which is the deportation case. So Elon is doing a petition to the same court of appeals in a separate case. This is within the same case. And here they're saying, the district court issued an order stopping on a nationwide basis the president's invocation of the Alien Enemies Act. And now they're continuing to try to pry sensitive information from the government. And the co-equal branch of the executive branch should be respected. Now, most fundamentally, they write, the district court lacked jurisdiction. Judge Boasberg could not issue this highly irregular nationwide injunction, writing, this court has long held that the president's authority is not subject to judicial review under the Alien Enemies Act. The only exception is that individuals who are detained under the AEA may challenge the legality of custody in habeas, but here they intentionally waive their habeas claims, and there is no such thing as a habeas class action that would support universal nationwide relief like this judge made up out of his butt. Even if a court could review the proclamation that Trump issued, it expressly makes the two findings that the AEA require. In Trump's order, it follows the law. Under the Alien Enemy Act, Tren de Aragua is linked to the Venezuelan government, operates as a government unto itself there, has engaged in invasion and predatory incursion into our country. Now, there is no basis for a court to look behind those facts under the law. That's the president's job. The president is accountable to the people for making those decisions because those are opinions. Okay, it's factual investigation, but you draw conclusions from the facts. We leave that up to the politically accountable branches. We don't leave that up to the judge to say, well, I disagree with the president on this policy decision. Otherwise, the judge is the president. And far from being novel, the president's invocation of the act in these circumstances is consistent with a long history of using war authorities against groups and entities connected to foreign states. But merits aside, Court of Appeals, the equities strongly favor the government, given the manifest harms to the public from letting dangerous aliens remain in the country. The injunction from the judge saying bring him back interferes with the president, violates his Article 2 powers, and is undermining the credibility of America with our international partners in Central America and jeopardizing international diplomacy. And so for all these reasons, the Court of Appeals should stop the improper interference by Judge Boasberg. They write, Trump to the Court of Appeals. As the government explained, the district court's unusual orders, while styled as TROs, are actually appealable because they say the nationwide halt can wait. But that's wrong. Even the order's temporary period has caused serious foreign policy harms that cannot be remedied. Boasberg has threatened to scuttle carefully removed operations that involve sensitive negotiations, and the court is continuing to pursue intrusive inquiries into Trump. This diplomacy is already fraught given the TDA's dangerous nature, designation as foreign terrorist, and being linked to hostile regimes. And challenges caused the prior administration to abandon the attempt to remove these people, but we're not going to do it. Now, you trying to undermine these efforts cannot be repaired even if the government wins. And the national security implications warrant immediate review. The court's orders are global. It makes removal of TDA members impossible. Even when a person does not pose a threat, removal delayed tends to become removal denied. And this is true a fortiori when dealing with some of the most dangerous criminals on earth. Plaintiffs agree immediate appeal is available from an order removing an alien to a country where he alleged he will face harm, but insist the government cannot immediately appeal an order to make it impossible to transfer them out. This can't be right. So for the same reasons, even if the court deems the orders enjoining this to be unappealable, it should nevertheless grant mandamus. If you don't grant us an appeal, there is no other way to protect the president's authorities or to safeguard Americans from the dangerous threats posed by the TDA. Further, the government's right here is demonstrated below, and they have no claim. So in the appeal, they write, a challenge to the AEA lies in habeas. If you think you've been wrongfully detained, file a petition for habeas corpus. And there is no other judicial revenue avenue. The challenge right now is to presidential action, which cannot be reviewed under the APA, the Procedures Act. In habeas, which is what they sued under, and habeas provides the only historic basis for alien enemies to challenge their custody. Long line of cases that support that. And the district court lacks the ability to review this. For over a century, courts have held that a president's invocation of his authority under the Alien Enemies Act is, quote, not to be subjected to scrutiny by courts, even though implemented by others. Someone else in another case said, the statute vests unreviewable power in the president. This is binding. And if you're unclear about what it means, unreviewable means unreviewable. It leaves no room for the APA or non-statutory judicial review, much less sweeping national injunctions. The only limited review courts have is habeas, to challenge the detention of another person. And even plaintiffs in this case appear to understand that venue is improper in D.C. They dismiss their detention claims orally in order to avoid the immediate custodian rule and are challenging elsewhere. And because jurisdiction is limited to habeas claims, there is no basis to certify a class to resolve those claims and apply this to all of the gangbangers in America. The district court also erred in failing to make affirmative findings under the rules. But they say that their claims fall outside of habeas. But the problem is this. Case law recognizes the only allowable challenge is a habeas claim. And so other theories of review must be rejected. They cannot sue for this. So in short, outside of this type of review, the control of alien enemies has been held to be a political matter subject to the president. They have no remedy other than a habeas petition brought in the district of their confinement. And I just want to pause on this, right? A conversation that's happening out there is let's just have Congress divest them of jurisdiction. But that, of course, presumes that the courts will follow the direction that divests them of jurisdiction. They already don't have jurisdiction over this, and they're hearing it. Okay, Chutkan already doesn't have jurisdiction over the EPA cancellations, which are contract disputes. But she calls them constitutional disputes because she's focused on agency action. What is the agency action? Somebody canceling the contracts. But she just reframes it that way, right? So you can divest them of everything, but they just say, oh, well, it's a constitutional problem. They just do it anyways. So the proclamation from Trump is lawful. The president can issue a proclamation. There is a declared war or an invasion or a predatory incursion. It must be perpetrated. And that hostile action must be by a foreign nation. And guess what? Trump said that exactly. It's the Maduro regime, functions as a government. Parts of Venezuela, they're invading. And so they're trying to undo that. They say, well, it's not actually an invasion. They say it has to be a military invasion. But that's not what the law says. The full definitions of preferred dictionaries actually support us. Invasion means a hostile entrance into the possession of another. We're clearly being invaded. Now, they say it's limited to foreign sovereigns. They say no. Actually, the TDA is a part of the Maduro regime. It is. It's virtually indistinguishable. There's no compelling reason to say this doesn't apply to them. And their attempts to minimize the history of military action also misses the point. The U.S. is facing hostile forces at the border. And they can't illegally bypass other provisions. The AEA is a key authority that Congress has seen fit to retain. And it directs the president, including Roosevelt and Truman used it, to protect the country. And it's not subordinated to other areas of the law, and there is no conflict that matters or that is important here. So they say that the Trump doesn't have authority, but that doesn't withstand scrutiny. They fail to meaningfully address the long-standing Supreme Court precedent about the president's expansive authority over immigration, foreign affairs, and national security. The exercise of authority by the president, in this case, falls within the long-standing powers that we've already seen. Now, what this court has done is impede the president from using his authority to address a predatory invasion by a hostile group. The orders undermine the delicate international relations that exist between the countries, and individuals associated with TDA are being brought back into our country. The district court's orders divest Trump of its key powers of foreign affairs and national security. The equities plainly outweigh the equities of permitting illegal aliens linked to hostile powers and terrorists to remain in the United States. U.S. national security is of paramount importance, and they can file habeas claims, not class actions as gangbangers. So this court should stay the sweeping universal injunction. And precedent supports this. You are not allowed to probe the national security and foreign policy decisions of the president. And you limited procedures here. Your injunction undermines longstanding deference to the executive branch. And so for all of these reasons, Trump says to the Court of Appeals, Judge Boasberg's decision to stop the deportations of Transgender should be stayed, and all of his other orders should be stayed pending appeal. So that rounds out the TDA deportation case out of Judge Boasberg. And of course, we'll see what the Court of Appeals does. We've got briefings, I think, scheduled very soon on this one. So oral arguments scheduled for Monday, March 24th, 2025, 1:30 p.m. Eastern Time, 30 minutes each side. Probably will get oral arguments, audio on that. And so we'll keep our eye on that one and see what happens next week. Thank you for subscribing and joining as we do. All right, my friends. So some good updates there today. Quick recap for those of you who are just joining us. We talked about the Department of Education and read through the actual executive order explaining what it is doing and why it is needed. We can't read and write anymore in this country. We can't speak good. It's not good. So we got to get more smarting on our brains, happening soon. So hopefully that gets underway. We heard from the usual whiners, Tish, Schiff, and Randy. Then we talked about what's happening with the arrest of the Tesla terrorists. 3 people charged. We don't know exactly with what, but Pam Bondi did make that announcement today. 3 people arrested with Molotov cocktails. And I think it is a much more expansive operation than 3 randos lobbing explosives. So we talked about that. We also covered Elon's lawsuit versus the states. He filed a major motion to dismiss their claims. I think it's 18, 19 states or however many sued. And now we'll wait for Judge Tanya Chutkan to issue a ruling on that one. Then we had a quick update on the trans case. So-called Rachel and Ellen are going back to the women's prisons. So they'll be back there. We'll see what Trump does, whether he's appealing it or not. We also talked about Perkins Coie and how Pam Bondi came out swinging on this one. That was fun. Said, okay, yeah, Judge, I notified everybody about your little order, but we also think you're wrong, and we're going to do everything we can to not work with these corrupt lawyers. My words. So good stuff there. We also talked about Boasberg, the Boasberg case, and we snuck in a little bit of a detour there to talk about the Elon case again and his petition for a writ of mandamus. And so we had a lot of legal updates here, my friends. And now it's time to hear from you. And we'll see what you have to say about all of this. Thank you for being here. Thanks for hanging with us as we go through these legal updates. Thanks for the donos. Thanks for the super chats. Thanks for becoming membos. Thanks for inviting everybody you've ever known, loved, or met, or talked to, or even thought about to come join us when we're back here tomorrow. Now let's see who's here. Thank you for being here, my friends. We got some great comments. And thank you to our amazing mods for modding the fort down for us and keeping things so nice and beautiful around here. Yeah, we had a fun conversation this morning about Teslas and electrifying your manly bits. Yeah, it's good times. Hey, what's going on? Thank you, Donut, for clipping for us today. And here we go, baby. It is almost a Friday. We're looking forward to that. Thank you for that one, Donut. Hey, Mark Burton is here. Says, hey, 10 months as a member. Oh, I missed the 9 months. I thought it was this month. Oh. Well, you got a baby in there that's ready to pop, man. So congratulations to us, Mark. We got a new baby in the house. Thanks for being here for 10 months and supporting us all this time. Congratulations to everybody here. Chad H, what's up? Big D is here. Chad H, Big D, just joined up as a supporter. Thank you, Chad. We'll see you tomorrow on the members only morning stream. And Membos, we had a great stream this morning. So if you're looking for more stuff to check out, other news, we covered more of it this morning. Mock Schnell says, well, going to have to go back into the office starting 4/12/25 per the director of the undersecretary of the VA. So going to toss a few more Membo gifts. Mock Schnell. Thank you, Mock Schnell. You're celebrating with Membos? Thank you for doing it. Thank you, Mock Schnell. I hope you're happy about that. And we appreciate what you're doing for us and our friends at the VA. We appreciate you. Thank you for that, Mock Schnell. Hey, G-Men is here. Says the Ninth Circuit found that magazines with over 10 rounds in a semi-auto are not protected by the Second and that they are accessories. What? Well, a lot of people are now criminals, huh? This judge dissents by making a video with his P320 showing how the logic of the majority means everything is an accessory, including a trigger barrel, until you get down to the serialized component by which itself is non-functional. It is a beautiful proof by contradiction showing that their ruling is unconstitutional. Yeah, judges have some of the dumbest knowledge when it comes to anything that's really like technical or functional. So, not all judges, but a lot do. You try to explain to them how a machine works, or how a gun works, or how some technology works. Just like, whoop. G-Man, thank you for that. Can we get the IQ points back even if we already graduated from public schools? Yeah, I think by proxy. Yeah, there's like there's a global consciousness, and now that we've gotten Department of Education out of there, we're all better for it. Can't you feel it in your brain already? Mock Schnell. Hey, 20 Membos coming in. Thank you, Mock Schnell, for doing this. Who's coming in? Pizza. We got Clark Christo. Fun Size. What's up, Will H? Gina's here. Doris Nogueras, Doremi, is joining up. Lenda Robertson, we got Prince Vibes, Sonic Garage Guitars, Wes Coven Adodge, Paddlin, Candace Alexander, Alien, the Magic Goose. What's going on? We got Ken Burrows, Melissa Morgan, Carrie Anthony, G. Usury, Pete, Steffi, and Mighty, family of God. Gifted membos courtesy of Mock Schnell in the house. More speed. Hey, what's up? We got Threads of Hera. Good to see you, Threads of Hera. We'll see you tomorrow on the Membos Only stream. And Mock Schnell with 20 more Membos. What's up, Scott Mouse? We got Sign Deb, Brian Peterson. We got Rich H, Verity, G Yikes. We got Apocalypse Dan, Marion Malawi, Moloney. We got Deller Finn, what's her name? Chief Librarian Mayonnaise. Susan E, Ortiz, Bushmaster, Mike Chaput, Mike Forno, Jar Jar Binkset. Remember Jar Jar? Isabella D, Jana Queen, and MSM Rocket Softball. Gifted membos courtesy of Mock Schnell. Bringing in 20 new membos on the first round and then another 20 more on the second. Thank you, Mock Schnell. Says, the good Lord and my parents taught me to do what is right in life and given me a good life and enough money to live comfortably. So passing it along to others. Love you all. Mock Schnell, man, what a nice thing. Sounds like you had amazing parents and like you're living a fulfilled life. And that is an amazing thing. So thanks for that. Thanks for spreading the love and sharing it around. You're a good man or person. Thank you, Mock Schnell, for that. 40 new membos from Mock. Hey, Rob, MAGA Michigan Patriot. Why is nobody looking into Randy Weingartner's teaching history? Claims to have been a teacher, but she is a good teacher, or did she completely suck? I don't know. Someone looked into it. Was she actually a teacher? Yeah. Hey, Off-Label Podcast says, going to be the last I can support you with for a min, but Illinois has 30 schools that not a single child in them can read a grade level. Not one. Wow. Yeah, and I've seen those like on X when you're scrolling around. You'll see those videos that pop up from teachers saying, my kid, kids can't read, kids can't write. I'm losing my mind. Doesn't sound good. Off-Label Podcast, live streaming right next door. Thank you, Off-Label. Here's one. Something to increase everyone's IQ points by at least double digits. Yeah, see. That was from a morning Membo stream. Anybody know what I'm doing right there? What am I recreating? This is like a game of Pictionary or whatever. Charades. It's the Hakeem Jeffries, obviously. It's the Hakeem Jeffries. That's how he talks. We're making fun of him. Hey, thank you, Geegum Geegum, our meme smith extraordinaire, for capturing that. Ixnay Acking Pay, it's the Ops Cray, woo 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 woo. Yeah, I think it was the Hakeem. Is that what we were doing? The Hakeem. Hey, Sheila Pooh, I am convinced the schools keep our kids dumbed down so they are easier to brainwash. I think that's probably true. And I think you can go back to history. I read a great book on that. What was that book? I read a book on the education system, or listened to it. It's on my Audible. What was it? It's about the education system, and it was like brutal. Where was it? Come on. I can't find it, man. I buy a lot of books, but don't read them all. Anybody else do that? Oh, there it is. Weapons of Mass Instruction by John Taylor Gatto. I like that book a lot. Really good book. It's like how we're all just trained to be automatons. That book, yeah, wild. Weapons of Mass Instruction was a good one. Hey, what's up? Thank you, Sheila. Mock Schnell. I graduated in 1979, and California already had started what my parents called the dumbing down of America. And they continue to do this under the Department of Education. Yeah, if you're dumb, you don't know anything about inflation. You just work and become compliant on the state, and you just act like good tax cattle. You just get sick, and everybody just kind of pumps you up and steals your life from you, and then you die. And it's a giant Ponzi scheme. We don't want to live like that. Thank you, Mock Schnell. Hey, the Pie Baker. Rob, did you just say the crossed state lines with weapons? There are 2 Kenosha prosecutors out there shaking heads with PTSD. Yeah, remember Binger? And that other one? Yeah, maybe they cross state lines with Molotov cocktails and cross state lines to commit crimes. So, conspiracy, arrest them, raids on all of them. Knox, hey, happy Thursday, all. Wow, look at this result. 25 to life, triple felony, aggravated assault, which is, like top of the line crime. Aggravated assault, usually with a weapon, or cause some serious damage or injury. Reduced to a misdemeanor assault with time served. Must have been that suppression memo that was cranked out at 2 a.m. on Sunday. Those will do it, Knox. That's some good lawyering right there. And she's explaining that the cops did some corrupt garbage. And she identified it, brought it to their attention, and they said, oh, yeah. Would you like a misdemeanor now? Like, yeah, we'll take it. Amazing work, Knox. Thank you for keeping the pressure on them. Hey, what's up, Mayor Wolf in the house? Bringing in Jerry L. Gifted a membo, courtesy of Mayor Wolf. Thank you, Mayor Wolf, for doing that. Hey, Spuds is here. Yeah, Spuds, great to see you again. Spuds keyed us off on a good, fun conversation this morning at the end of the stream. Lisa McNeely, what's up, Lisa? Michael Lind is coming in. Brett Montgomery, DPO1, and Cajun Child. Gifted membos. Thank you, Spuds, for doing that. Hey, Jeff Lindsay, what's up, Jeff? Welcome aboard. Great to see you. Thanks for supporting us. Jeff Lindsay in the house. Hands one Peak on Rumble says the feds should purchase or lease Tesla battery cars and put it at dealers and on the street. Damage federal property, 5 years, $250K. Yeah, you can put all those like trap cars. You know those trap cars they put in the parking lots? Just put it on Tesla. And the Teslas have the Sentry modes. Like, it's recording you, people. Don't you know? Even that guy, he was spreading his butt all over the place. Gross. Who are these people? Like, I hate fascism, so here's my fecal matter all over your windshield. You're like, sheesh, man. Is fascism your biggest problem right now? What are you doing? Will Crump. Tishy James has filed a lawsuit over the laying off of 1,500 Department of Education employees in Massachusetts. She already did that already? She filed one already? Obviously, another hand-picked judge and another TRO. Amazing. Yeah, what's she doing over there in Mass? Joined in probably with their AG. Hey, Fred says, spoke to an attorney from Texas before the show. Awesome, Fred. Yeah, amazing. So I think KB is Knox Bierman from the great state of Texas. And Knox, you're amazing. Thanks for all you're doing with Fred. Hey, Fred, you're awesome. Thanks, bud. Hey, Rob Maga, Michigan Patriot. What's really funny is all these people actually think Elon is sitting in front of a camera going through all this stuff. Yeah, they're having a hard time articulating exactly what Elon is doing other than they're losing money. And so they're just wrapping all these things up in constitutional arguments, but it's just money, right? They don't want their money to go away or to get fired. Yeah, Uncle Bozy, Boasberg went ballistic today. Yeah, we read it. He did. He's a big baby. Will Crump, shouldn't Congress be drafting legislation to circumvent every last TRO against Trump? Republicans are not doing their job for us. I think that is true, Will. Congress could certainly just rescind the funds from USAID and do a lot, but they don't do anything other than just carry on the status quo. They're useless. Mommy Mima. What's up, Mommy Mima? Thank you for supporting us. Thanks for becoming a membo. We'll see you on the morning stream. And grab this morning. It was good. It's not old. It's good news. We talked about it today. Spuds. Hillary was co-president. Slick Willie said so. Hillary was co-president. Slick Willie said so. Yeah, remember she was doing all the whatever healthcare nonsense that failed epically. Knox. Hey, sharing this one from Substack. This is the El Gato Malo column. Best line from this. A mental break in which reality can no longer be discerned and where wild, unmoderated actions seem like apt response to the extraordinary provocations of a mind eating itself. Mistaking this self-delusion for an external stressor is a road to pants-on head rage rampages of vandalism, harm, self-harm, and who knows what else. Yeah, that's some nice writing there, Knox. Good stuff. Gonna have to go check out Substack, I guess. Thank you, Knox. Interesting. That cat looks like it's providing a lot of value there. That would probably be a much better therapist for most people. Knox, women don't get bras in women's facilities. They get an orange wife beater just like men. What do these dudes think this jail is? Victoria's Secret? That's a great line. It's a great line. Well, these don't give me the support I need here when I'm out in the yard. Oh, Colleen. Would Schumer saying publicly about the cases being on purpose be enough to investigate the judges? No, I don't think so. I mean, he shouldn't be saying that out loud. Like, that's not what we want our justice system to become, is a bunch of Democrat operatives who are installed by Democrats. Like, they're supposed to be selecting judges who are fair and impartial and upholding the Constitution, not Democrat priorities. But the process is innately political, obviously. And if he said something like, I paid some people off in order to get this judge in, and I think there are real questions about some of these judges and like their donations, their wives' donations, and all the things. It's like Judge Mercan with his daughter, except at the federal level. Not much different. Sharpie Guy, what's up? Says, Rob, what was Branko's suggestion about charging or maybe removing Fed judges in Congress? It's time for us, some small folk, to get busy tugging on our senators and representatives. Don't you agree? Yeah, he posted briefly. He just pointing to another part of the Constitution that talks about the removal of the judges that is not for impeachment purposes, which is that they enjoy office during times of good behavior. And if they're not acting in good behavior, you just remove them by congressional legislation or a resolution, essentially. You don't actually have to go through full impeachment, which means like impeachment is more like a censure, like a penalty, but they're not entitled to their office. Only subject to removal by impeachment, basically an alternative methodology. But I would refer you to him to have him explain it much better than I can. Sheila the Pooh, what's up, Sheila? Thank you for bringing in 10 membos. Broken Prophet is in the house. Devo Bronk, we got Kanani Miranda, Kiki Lee, what's up? Kobe Tiger is coming in. Heart and Soul, Butterfly Bee Stings, Lulu 101, Dan Nekovska, all coming in along with Ghost Warrior, courtesy of Sheila Pooh. Thank you, Sheila. A million hugs to you. Thanks for bringing in 10 new friends for us here. Lenny Malley, what's up, Lenny Malley? Reminding everybody to like, share, subscribe, share this on every social media you've ever seen. And God bless you all. God bless you back, Lenny. Sharpie Guy says 275 times and Coke Schumer chokes on his gallant words. From Sharpie Guy. Philip Butler says, can they transition the men's prison to a he-she? I don't even know what part of the genitals we're on right now. The men's prison to a he-she. Well, I guess if the judge has their way, then they might attempt to do that. But we don't really know. It's very confusing for me. This old guy says, logistical difficulties are the most difficult of all logistical issues to resolve without logistically causing any difficulties. That's right. That's what that letter said. Well, you know, we're going to have a meeting and a consultation on this one to resolve the difficulties in logistics. Wow. Well, what are the logistics that we need to schedule the meeting in the first place? I don't know. We should probably have a meeting to talk about that, because it's going to have to be a big meeting. We're going to need lunch. So, Jennifer, please join Voice of the People. So check this out. Go to Off Label Podcast as soon as we're done here. Hang out with Voice, hang out with Jennifer, and have a tremendous stream. Jennifer, thanks for plugging them. And I hope you guys have a rockin' stream. Right next door, easy to find. Glocky says, what did she know and when did she know it? Cori Bush's husband is indicted for wire fraud, allegedly submitted false applications to obtain COVID relief funds. Wow. Cori Bush. Wasn't that the same husband that was like her security guard dude she hired, was paying him from her campaign security guard services? He's like, yeah, I sleep next to her. Protect her. Yeah. Spuds. Trans prison. Be whatever you want to be in trans prison. Yeah. And get your shots and get flags and whatever. Will Crump, how much of President Trump's presidential power is going to have to be impeded by these inferior local Article 3 trial judges before SCOTUS steps in here and ends it all? we're probably getting closer to that. I mean, we're starting to hit the preliminary injunction phase. And from there, they'll go to the Court of Appeals, which will deny many of these things. And then from there, they can go to SCOTUS. Hey, Philip Butler says, if you lose clearance, you need to be investigated. And many things that could apply to, Philip, but perhaps Perkins Coie. S. Sinclair, what's up, S. Sinclair? And MWD just joined up as membos. Great to see you both. Thanks for joining up. We'll see you tomorrow. Ron Mead says, don't you love aggressive bureaucratic compliance? I love doing it during WedTech. WedTech. Yeah, I'm not sure what that is, WedTech, but that's exactly what it is. Oh yeah, we're going to comply with every order. And fortunately, there are like 100,000 layers of bureaucracy that we can just invoke to delay and muck up the process. What's up? FD Man says, you know, these judges are getting insanely stupid. Roberts and Barrett could have put an end to all this crap a month ago. Roberts is on the hook. Yeah, it's his branch. He couldn't get it under control if he wanted to. So for him to come out and talk garbage against the executive branch, which is a co-equal branch of government that is using its tools, talking about impeachment, or in other words, cajoling Congress to do it, is totally reasonable. Trump can't impeach these judges, unfortunately. I mean, you know, practically it's fortunate that we don't have too much power consolidated in one branch, but Trump can lean on the legislative branch to do it. Bullwinkle Sprinkles says Mark Caputo, the White House correspondent for Axios, was on Leland Vertrit for News Nation. He said all the lawsuits were anticipated, and Stephen Miller has wargamed it for years. That's awesome. Yeah, that's awesome. So they knew this was coming. It kind of feels like that. Hey, a fortiori, we got the word here. A conclusion that is inferred to be even more certain than another. Literally means from the stronger argument. Amazing. Thanks for looking it up for us, Donut. We got this one from Stephanie Carver. Stephanie, thanks for signing up to become a supporter. We'll see you on the Membo streams. Colleen says, I saw a convo between Chris Cuomo and Steve Bannon. It was interesting. It was on News Nation. I thought it might be interesting. Might be worth a watch if you want. Well, I like Steve Bannon. I kind of have a hard time listening to Chris Cuomo. Although, I think he's getting a little bit less obnoxious. I was able to listen to the Tucker conversation with him. Mostly because Tucker was talking. But thank you for the recommendation, Colleen. Chris is an interesting dude. G-Men. Yeah, he means Rob's electromagnetic balls. Yeah. That was from this morning. That's what was happening this morning. It was a fun time. Hey, thank you, G-Men. Rainbow Rabbit Hole. 4 months as a membo, says longtime lurker. Love the fam, though. Thank you, Rainbow Rabbit Hole. Thanks for becoming a membo. We have an amazing fam here. Thanks for becoming an even more integrated part of it. Doanne Burrill says, seems like everywhere you find Boasberg, funny, he's gnawing on one of Trump's ankles. 2 sisters and a daughter with USAID hookups, and recites him, him stat. Recite him, rescind him, impeach him, stat maybe, from Doanne. Yeah, and I think we saw some good reporting on that. They're all embedded in it. It's all just one big, incestuous, disgusting family. Hey, Sandy. Rob, executive branch has control over executive court buildings insofar as lease, janitorial staff for judges, electricity, security, everything else. If Trump feels funding for the federal court buildings need to be secure, the physical structure, and there is no money left to fund the copy machine, the court is closed. Yeah, you just I guess, somebody has to pay the water bill. So if you stop paying for the water bill, there's no toilets there. It's going to get even stinkier than Letitia James's feet when she takes her shoes off. Sharpie guy, if you were frying your setups, Spuds, how does Elon pop them out left and right? I'd honestly argue superpowered sperm, maybe. Gosh, this show. Everyone needs to buy a Tesla. That's where this was going. Are you frying your nads when you drive around in a Tesla? That's the question of the day. Elena, I hope not. Elena, what's up? Thank you for bringing in 5 new membos. We got Potato. Defective Potato. Man, they're still good. No potato is defective, okay? David Hurley, what's up? Lucas G, thanks for coming in. Doug Lackey and RTW / recommended status in the house. From Elena a.k.a. Neely. Thank you, Elena, for bringing in our new friends. Doanne said the typo on the last one was recuse. Recuse him, stat. Got it. Not recite him. Got it. I almost was close to that. Stephen O., 5 months as a membo, says, wait, so I can't make my mags pink like Ken? Oh, under the Ninth Circuit Court of Appeals firearms ruling? Yeah. Maybe not. Is that illegal? Have to ask G-Men. I didn't read that one. Is it illegal to have pink magazines like Ken? Craig R., thanks for this nice dono. Says, thank you for the work you do. Speaking the truth. Thank you, Craig. Thanks for supporting us, my friend. Couldn't do it without you. And really grateful you're here. And I hope you have a beautiful rest of your week. Thanks for the nice dono. FD Man says, I don't think Weingartner liked that because no one would let her. I seen her photo and it is not inspirational. From FD Man. Thank you, FD Man, for that comment on Rumble. G-Men says, I have way more books than I have read, partly because I'll buy multiple books, start one, move to the next, finish that, then not go back to the original. Yeah, I do that all the time. I was looking through my Audible. I've got like all these books I started. I'm like, oh, that's a great book. I should finish that. Oh, that's another one. Oh, there's another one. Oh, there's another one. And then Audible gets me because they do like the 2-for-1 sales. And I'm like, ugh. Or they do those $2.99, like $3.99 sales, and I'll buy like 5 books. And I'm just like, oh, that sounds fun. That sounds fun. I'll listen to that for sure. I never do. It's a kind of a problem, all right. I'm the first step is to admit it to someone you know and love. Deluxe Night, 10-round capacity magazines are so dumb. Rob, you should check out some of those wild boar hunt videos in Texas. I've seen them. 3 people with ARs, 30-round mags. They still had to run from the horde of boars. They get huge in Texas also. Yeah, those boars are scary, man, and they're fast as hell. And I've seen videos of those guys like, I don't know, bolt action or pumps or something. Not 30-round AR-15s, not that. Probably shotguns. I think I'm trying to remember the videos. And just, reloading that thing, boom, miss. It's like right there, get it. Like, woo! That was close. David Hurley. Given the 10th Amendment and the enumerated powers, is the Department of Education even constitutional? Great question. I'd argue no. Yeah, so constitutional interpretation right on that. So there are enumerated powers that the Congress has, and to all else is reserved the states. So where is the Department of Education enumerated in Article 1, Section 8? Is that right? Is it in there? I don't think it is. So it's not constitutional. It's reserved to the states. Never should have been created. More here. What's up, more here? Those hand signals are like how the bookies communicate on British racecourses, aka racecourse tic-tac. Oh, Hakeem Jeffries. Yeah, that's how he communicates to everybody. Like, we're going to do this and 1, 2, 3. Thinks he's like Obama. FD Man says, I wipe my butt on your fascism, your silly electric thing, and I spit in your general direction. Pooey. Yeah, Democrats for butts. Democrats butts against Nazis. It's their latest 501c3. Democrat butt juice against MAGA Nazis. FD Man, is it time we stop tugging and start tugging our senators? I don't know what that means, but we want to keep political pressure on them. Doanne, Dem organizers of DogeQuest knew Teslas were loaded with surveillance, but they left it out. They treat their people like disposable goods or like useful idiots. Yeah. What are they? Is there a Democrat butts operation underway? Spuds. Anyone who deals with electromagnetic energy will tell you that you need to consider ANSI standardized PPE exposure levels via NIOSH, all dictated by OSHA. Unfortunately, NHTSA is the agency that regulates safety issues for cars, and due to stovepiping, those agencies do not talk to one another. How is Elon popping out so many kids? Elon needs to work on that. Besides, I doubt Elon drives entry-level models. So you think Elon's cars have NADS shielding for Elon that they're not given to the rest of us peasants? Well, I hope that's not the case because we need our NADS. Colleen, it was more what Steve said on it. Chris was Chris, still interrupting every time you turn around. Yeah, it's like hard to listen to him. He's like, well, I've got a much better, smarter point than you. You're like, no, you don't. Then he says something stupid. You're like, see. G-Men, I guess we have the answer to population decline, boys. Go electromagnetized, boys. We don't know what's going to happen after a lifetime of driving around in electrified vehicles. Sandy, the amici filed at the Court of Appeals of 25 states is significant in the AEA case. I have not seen, there's so much stuff that's filing. Everyone is caught up on learning what rules we have to follow instead of what power we have to make the rules. Tell your viewers to map the states in this amici and think blockade of the left states, needing gas, food, and supplies. This is ugly, but rules are not their friend. I'm actually interested in that, Sandy, and I was thinking about asking AI about that. There are certainly, like we're seeing population shifts, and I think that red states are going to pick up a bunch of seats in this next census because people are leaving the blue states going to the red states. I'm wondering if that is happening across ethnicity, race, religion, sexuality, gender ideology, all that stuff. Like, is that same thing happening? I know populations are moving, but is it happening across other domains? And what is the long-term trend of that? Like, is Ilhan's district going to become Somalia, where Texas becomes Starbase? And is that dynamic going to increase over these coming years? And what does that do for a country other than break it apart? Deluxe Knight, defective potatoes make delicious stackable Pringle potato chips. If you know, you know. Yeah, there's really no bad potatoes because you just turn them into what? Hash browns, which are delicious. So FD Man says, be like JJ from Good Times and use some dynamite on the boars, on the boars in Texas. That sounds pretty amazing. I think I saw one out of a helicopter, right? Guys just out of a helicopter, just taking them out. Crazy. Former strange radical left-wing Democrats now hate Teslas more than they love the country. You notice that I didn't say their country. Yeah, it's a strange thing when you hate the leader of your country so much that you want to see your country fail. It's pretty strange. Like, as much as we disdained Joe Biden, we were upset with Joe Biden because of what he was doing to America, having it invaded, getting us involved in foreign conflicts and all the things. And maybe the left would say that too. But what do they base it on? It's certainly not the Constitution, other than what, democracy? They just say that all the time, democracy. Well, what do you mean democracy? Like Zelensky in Ukraine. Do you understand what the word means? I don't think so. Drew Godkin. What's up, Drew? Thanks for becoming a member, my friend, and supporting us. We had a great members only stream this morning, and we will have another one tomorrow morning. Can't wait to see our new members there. Let's see what's cooking on X right now at the moment. We got some friends over here. Let's see who's here. James Pepper, Z Shaded, LA Snarky Retiree. Tons of stuff. What's up, Mike? Thank you, Mike. Says, love the show. We bring receipts. Appreciate that, Mike. Thanks for sharing that one. Hey, Retired Dave. Trump called out SCOTUS about an hour ago. Missed that one. Chief Justice Roberts was caught in a secretive invite-only club for elites with Boasberg, Howell, Mehta, and Ketanji. Wow, that sounds like a burner over from the Gateway Pundit. Maynor is here. Secret invite-only club with John Roberts. Wow, that sounds like a wild one. Clay N., good to see you. Change of venues hard because they're suing the agencies in Washington, D.C., right? The agencies are there in D.C., so they're physically there, so the court has jurisdiction over its geography, which is a good reason why we should send a lot of these agencies to Texas or something, so that when they sue, there is recourse there. Hey, Philip Butler says, low T guys buy electricity cars. EM is not the cause. That's a personal attack, Philip. FD Man says, Democrats seem to love everything, hate everything good, just merciful and godly. Seems like they are just the devils. Yeah, I think one side likes to build things and create things. The other side doesn't. The other side looks at what was created and says, we need some of that. And it's just communism. It's just something that's been around for centuries now. So it's not more complicated than that. I think some of it can be unprogrammed out of people, but some of it not. So great comments, my friends, on X. Thank you for sending those in. Make sure we didn't miss some others there. Z Shaded and Snarky Retiree says, you mean that you are supposed to read the books you buy? That's what they say. I think you're supposed to. Hey, Shaded, the power to pardon is not merely an instrument of mercy, but a sovereign affirmation of the independence of the executive, on authority beyond the judiciary's grasp. Great comment from Z Shaded. Appreciate that one. Made Ghost, good to see you. Mainer's in the house. Clay N, nice to see you. And James Pepper, yeah, send the deportees right back to the judge. See how they like it. Angela Phylan, thank you, Angela. Thanks for becoming a membo and supporting us on the Membos stream. We will see you back here, of course, tomorrow morning for the Membo stream. It's noon on the East Coast, I know, but it's morning for us. Hey, thank you to our amazing mods and meme smiths who mod the fort down for us and keep things oh so nice and beautiful around here as we hang out. Rob, MAGA Michigan Patriot, says, if a judge or multiple judges are caught in the midst of a criminal conspiracy, what is the action that is needed to be taken? Impeach him. Yeah, impeach him. Or charge him. Either way. Charge him and then impeach him, or impeach him and then charge him. Either way. I think you can make arguments for both of them. Thank you to our mods. K Bean in the house. Donut Mind Me. We got Carrie B, Playing Hooky, Dog Digger, and Jannak modding the fort down for us, keeping things nice and orderly. Shout out to our meme smith Jigum here today with our hat gif. And my friends, that is where we're going to leave it on this lovely Thursday afternoon and Thursday evening. We're coming back tomorrow. It's going to be a Friday. We're excited about that. We're going to close out the week strong with the best show of all time, and we can't wait to get into it. So tomorrow we will be back here to do it again, and in order to do it appropriately, we're going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.